Which of the following statements are not correct? Stranger to the contract cannot sue both in English and Indian law. Wrong. Stranger to the contract can sue both in English and Indian law. Right. Consideration can be moved from promissory along with English and Indian law. Right. Consideration can be moved from promissory or any other person in Indian law. Wrong. Not correct are 1 and 4. Correct are 2 and 3. When a man advertises that he has a stock of book to sell, he is making a invitation to offer. Match the following. Satyabrat Ghosh versus Bhangri Ram. Frustration of contract. West Bengal Financial Corporation versus Gluco Series. Anticipatory breach of contract. Union of India versus Steel Authority of India. Unjust benefit under mistake. Salima Jabin versus National Insurance Company. Novotion. A contract stands discharged by all of these: performance of the contract, frustration of the contract, novotion. On which one of the following ground a party to contract cannot be discharged from performing it? Commercial hardship. In which discharge of performance is allowed? Destruction of subject matter, change in circumstances, non-occurrence of contemplated events. Under Contract Act, consideration may proceed. Both A and B from the promisee, from the person other than the promisee. When goods are displayed in shop window with price tag attached to it, them the offer come from the customer. A unilateral contract in which one party is bound is known as executed contract. The word not defined in specific relief act shall be understood according to the Indian Contract Act. Discharge of contract can happen with all of the above: frustration, performance of contract, impossibility. Display of good in the shopping mall is invitation to offer. Defense of non-est factum is available to the contracting party who has committed mistake as to the nature of contract, unless it is specifically provided in the contract of sale. Which one of the following will not be regarded as essential of contract of sale? Stipulation as to a time is not regarded. Which one is regarded as stipulation as to the time of performance, stipulation as a method of performance, stipulation as to the time of delivery of goods? Who said anticipate Anticipation of to a contract is what is light match stick to a train of a gunpowder. Sir William Anson. Consider the following statement. Regard the Uberium Fidei and find out which one of them is correct. If falls within the class of classes which require utmost good faith, right? Every contract is a contract of Uberium Fidei. Wrong. Contract of insurance is an example of Uberium Fidei. Right. 1 and 3 are right. B. 1 and 3 are only. In which one of the following case frustration was applied? Answer the given code below. Answer is all. Frustration of contract is applied in all cases. Paradine versus Jane, Taylor versus Cadwell, Kinry versus Henry, Clerkwood Property in Investment Trust Limited versus Langhout Investment Trust Limited. Which one of the following pair is correctly matched? Section 29. Agreement void for uncertainty. When a bookseller advertises that he has a stock of book that he is making an invitation to offer. A standard form of contract is also known as both A and B. Contract of addition, unilateral contract. Contract of Uberma Fidei means contract of utmost good faith. Quantum merit means proportional earning. Which country does not recognize a part of the consideration? Country does not recognize past consideration. United Kingdom. Announcement of reward to a general public through newspaper to find a stolen good is an offer. Ghanshyam and Afzal are good friends. They are traders and together keep doing business transaction very often. In April 2016, they enter into contract. Afzal had certain confidential information from his private source about some change in the prices that would affect Ghanshyam's willingness to proceed with the contract. As per Contract Act 1872, identify which one of the following is applicable. Afzal is not bound to inform Ghanshyam about the change in the price. The leading case of Harvey versus Facey related to which one of the following cases? Invitation to offer. Novoson. Section 62. Unjust enrichment. 70. Party competent to contract. 11. Disposition of property inducement threat to the cause of death. Section 15. Tender is invitation to offer. Match. Lalman Shukla versus Gauri Dutt. General offer. Twigged versus Atkinson. Privity of contract. Balfour versus Balfour. Intention to contract. Khan Gul versus Lakha Singh. Restitution. Case of Nash versus Inman. Related to necessity. Carlyle versus Carbolic Smoke Ball. 1892. The court ruled that an offer need not be made to a certain person. Theory The theory on which quasi-contract obligations are based is to prevent unjust enrichment. Who considered to be real founder of this theory? Lord Mansfield. Some part of law of tort have been codified by statute relating to particular branch of law, and one of them statutes are Indian Contract Act 1872. If a proposal has accepted, subject to certain condition, the contract is not constitute at all. Carlyle versus Carbolic Smoke Ball Company. The definition of wagering agreement was given by Justice Hawkins. Invitation to offer. Harvey versus Fishy. Anticipatory breach. Foster versus De La Tour. Restitution. Leslie R. Limited versus Sally. Implied contract. Uptown Rural District Council versus Powell. Which one of the following is related to cross offer? Tin versus Hoffman and Company. Which one of the following is essential contract does not find place in Indian Contract Act 1872? Intention to contract. Restitution stops when repayment begins. Is a principle which correctly applied against minors only. Bank guarantee in the independent contract between bank and beneficiary. There are two important theories of doctrine of frustration: the theory implied term and theory of unjust and reasonable solution. Doctrine of supervening impossibility will not apply in the following case. Difficulty in performance, commercial impossibilities, strike, lockout, and civil disturbance. Rectification of an act can either be expressed or implied. For the acceptance of mere mental resolve to accept would not be sufficient. There must be some external manifestation and the intent by speech, writing, or other act. It was held by Supreme Court in the case of Bhagwan Das versus Girdhari Lal and Company. Difference between a contract and social agreement is that of intention to create legal relationship. Match. Satyabrat Ghosh versus Mangani Ram. Doctrine of frustration. Raj Rani versus Prem Abid. Minor agreement. Intros Limited versus Miles for Eastern Corporation. Communication of acceptance. Harvey versus Facey. Invitation to offer. Assertion. A stranger to a contract cannot enforce the contract. Reason: he is not a party to contract and cannot be take benefit. Both are true. Match: a railway timetable is a general offer. Public notification for tender, invitation to offer. Picking up an article from slaves and putting it into basket in slave mall. It is not the acceptance of offer. A says to B that if A's offer is not accepted, B should say no. Immediately B keeps silent. Is acceptance of an offer. A showed that the child of B is drowning in water. A saves the child from drowning in water. B promises to give him 25,000. In this context, which one of the following preposition is correct? B is liable because the agreement is nudum pactum, not nudum pactum. A sent his servant to B to trace his lost nephew. When the servant had left, A announced a reward of 501 to anyone who traced the boy. B found the boy and brought him home. Then came to know about the reward. Under Indian Contract Act, he can claim reward. No, because he did not know about the offer when he found the missing boy. Under Indian Contract Act, publication of notice inviting tender is notice inviting proposal. Which one of the following statement is incorrect? Every contract is an agreement, but every agreement is not contract, right? The test of contractual intention should be objective, not the subject, right? Acceptance of complete when it is communicated to the offerer, right? The party inviting tender is 18-year-old to accept the tender, wrong. The rule laid down in Adam versus Lindsay was approved by House of Lords in the case of Dunlop versus Higgins. Under Indian law of contract, consent and Adam means to agree on same thing in the same sense. Match: counter proposal. Hyde versus Branch. Damage for breach. AKAS Jamal versus Mullah Daud. Acceptance by conduct. Hindustan Cooperative Insurance Society versus Syam Sundar. Commercial hardship. Ganga Saran versus Ram Charan Ram Gopal. A contract over telephone became complete at a place where acceptance is heard. In which one of the following case it was held? Bhagwan Das versus Girdhari Lal. A lent rupees 1 lakh to B and B promises to repay it with interest of 12% per annum. 1 year. The agreement also provides that if the amount repaid within 6 months, rate of interest will be 10%. The stipulation is valid. A entered into contract with B to sell him 100 balls of cotton and afterward discovered that B was acting as an agent for C. For the price of the cotton, A may sue only against C. Under Indian Contract Act, good display in the shop window with price label will amount to invitation to offer. Match. Acceptance of offer by conduct. Bhagwati Prasad Pawan Kumar versus Union of India 2006. Pitching. National Association of Software and Computer versus Ajay Sodhi. Contract through email. Sapna Ganguly versus RS Enterprises. Promissory estoppels. Ali Mohammad Sheikh versus Jammu and Kashmir. Compromise of dispute claim is a good consideration for the contract. The concept that say unfair, unconscionable contract of clauses should not be enforced is known as culpa in contrahendo. A suit for money paid and received does not lie in the following set of circumstances. Money paid by the plaintiff to a third party, but the benefit to the defendant which the parties seek to recover. Which one of the following combination is correctly matched? Responsibility of finder of code. Section 71. Surety liability 128, sub agent 191. This one is right. MC George versus MC George. Intention to contract. Wicks versus Tyblade. General proposer. Henderson versus Stevenson. Reasonable notice. Curie versus Misa. Constitution.